This is an appeal in the matter of advanced technology provided to industry and rules that limit security.
Good morning, my lords. In this appeal, I appear on behalf of Uniserve, who were the defendants at the trial, and I appear with Mr. David Walsh, KC, and Mr. Edward Mordaunt. And my learned friends, Mr. David Lewis, KC, and Mr. Edward Knight, appear for the original claimants of the trial, Advanced Multi-Technology for Medical Industries, who trade as high-techs, and therefore we refer to them as high-techs for the purposes of the appeal, Caramel Sales Limited, and Mr. David Popek. And your lordships will have seen that this is an appeal from a judgment of Mr. Nicholas Thompsell, sitting as a Deputy Judge of the High Court on the 4th of July 2024. Your lordships will have received a timetable for the next 3 days, which sets out how the parties suggested dealing with the various matters on appeal subject to the court's approval. And you'll have seen that the intention is that Uniserve's appeals will go first, and I will deal with grounds 1 to 4, and will also deal with my learned friend's respondent's notice in respect of particularly grounds 1 and 2. So I will deal with those, and then Mr. Walsh will deal with grounds 6 and 7. Then Mr. Lewis will respond to our appeal and the respondent's notice points, and then Mr. Knight will open on what we call the Commission appeal, which is the appeal of Caramel and David Popek under the Commission agreement.
Yes.
And then the intention is that I will reply on our appeal and deal with the response to the Commission appeal, and then finally Mr. Knight will have a right of reply on the Commission.
Right, well, we're grateful to you for agreeing that. We're content to proceed in that order. We're not entirely persuaded that these appeals should take 3 days, but we'll see where we go.
Well, my lord, I think that we're probably with you that we don't think it will take 3 days. That we think it'll probably take 2 days with the risk of going into the third. But obviously, one never knows.
No.
My lord, so I'm going to, as I say, deal with grounds 1 to 4 first, and my learned friend's respondent's notice. And your lordships will have seen that the trial concerned a contract for the delivery of 80,000 Type 2R masks during the height of the COVID pandemic in 2020. And your lordships will have seen the supply contract, which is at the heart of some of the issues in this appeal, in the core bundle at tab 27. And your lordships will have seen, if we start at page 394, terms and conditions for the supply of goods. And if we pick it up, you can see Uniserve and that the supplier is High-Techs, the date of the contract 21st of April 2020, and the type of goods, Type 2R surgical disposable fluid resistant masks. And then it says the contract made on the date set out and subject to the terms set in the order form. The schedules, Uniserve and the supplier undertake to comply with provisions of the order form, and the schedules and the performance of the contract. And the heart of it is the next paragraph. The supplier shall supply to Uniserve, and Uniserve shall receive and pay for the goods on the terms of this contract. For the avoidance of doubt, the contract consists of the terms set out in the order form and the schedules, together with the annexes. And you can see that the schedules were key provisions, general terms, definitions, and additional special conditions. And going over to page 395, again, if we pick up at box 3, the supplier shall supply the deliverables described below on the terms set out in this order form, the schedules, and any current or future agreed annexes. In the event, jumping one paragraph, in the event of any conflict between this order form and the schedules, this order form shall prevail, and the deliverables are described in the next box, goods. Type 2R surgical disposable fluid resistant masks. Collection shall be ex works in accordance with the following instructions, and it gives the collection address and the contact name. So this is an ex works contract where the seller is obliged to supply the goods or make the goods available for collection at the agreed location. So under an ex works contract, the seller delivers the goods when it puts the goods at the buyer's disposal at a nominated place. And of course, under Section 27 of the Sales of Goods Act, it's the seller's duty to deliver the goods, which in this case is X works, and then it is the buyer's duty to accept and pay for the goods. That is how a standard sale of goods contract works. So in this case, the first obligation is on the seller to supply the goods X works. And the next important point is dates of delivery. It sets out a schedule with dates and the number of units. And one can see that the total units scheduled is 80 million. So under this contract, the seller is obliged to make a total of 80 million units available. The dates of delivery are set out in that box and identify an amount to be made available on each date. The reference to the total units under the box in our submission shows that the amounts in the boxes are cumulative. You have to give a total of 80 million under this contract. And we would submit that a reasonable person looking at the terms of this contract would understand that on each of the dates identified, the seller must provide additional masks from the previous date until the cumulative number of 80 million masks are made available by the seller. Between pages 397 and 402, you can see at the top of 397 specification, and it was dealt with by identifying various certificates. And that is the specification, 401, the test, and 402, the face masks. And there was an issue your lordships may have read in the judgment about whether that therefore required under the specification nose bridges, which seems to have been one of the problems that led to problems with manufacture at an early stage.
But that issue has fallen away.
That issue has fallen away completely, but what hasn't fallen away is there were major problems at the beginning of this contract. And then 402 identifies the term of the contract, and we then get to Schedule 1 key provisions at 404, and one of the important provisions that's referenced in the judgment, your lordships would have seen at 405, clause 5.1. And it says, time is the essence as to any delivery dates under this contract. And if the supplier fails to meet any delivery date, this shall be deemed to be a breach incapable of remedy for the purposes of clause 12.4 of Schedule 2. If your lordships keep your finger in 501 and go on to page 423. Oh, sorry. 416, I apologise. 416. Your lordship will see Schedule 2 at the bottom of the page on the right, 12.4. Either party may terminate this notice by issuing a termination to the other party if such other party commits a material breach of any of the terms of the contract which is not capable of remedy, or in the case of a breach capable of remedy, which is not remedied in accordance with a remedial proposal. So if we go back to 405, time is of the essence as regards Hi-Tech's duty to deliver the goods, and is an irremediable breach for the purposes of clause 12.4. But it is not. Time is not of the essence, and it is not an irremediable breach for Uniserve to fail to accept or pay for goods. So Hi-Techs must supply the goods, must deliver the goods X works, and that is of the essence. And clause 6 on 405, supply of goods, you can see 6.2, the supplier shall supply the PPE goods to Uniserve in accordance with the terms of this contract and in accordance with relevant requirements. And then 6.3 sets out that the supplier shall ensure the PPE supplied it conforms in various respects.
So far as the sale contract is concerned, it's Network's contract, but are Uniserve free to take the goods anywhere in the world, or do they have to bring them to the UK?
Under the terms of this contract, it's ex-works, so there is no obligation as to where they have to be brought after that, under this contract.
Right.
You may under the commission, I imagine your Lordship's question relates to the commission contract, which will come to...
Yes, which might raise
I understand,
questions.
yes.
Yeah.
Well, because, I mean, your Lordship's seen the way the judge dealt with it. He says it's only triggered when it comes to the UK. So your Lordship's question is, well, are they free to do anything else? Yeah, which we'll come back to.
All right, that might be a treat for Thursday or Wednesday. That might be a treat for Thursday or hopefully Wednesday afternoon.
I get what your Lordship's saying. Yeah. And then the final clause to just look at, which is also relevant to the appeal, it is at page 423. Clause 26.4, the delay or failure by either party to insist upon the strict performance of any provision, term or condition of this contract, or to exercise any right or remedy consequent upon such breach, shall not constitute a waiver of any such breach or any subsequent breach of such provision, term or condition. If we then just go back to 395 and the original schedule, your Lordship will see the original dates. And it's common ground that High-Tech's accepted that it was in breach of the supply contract for failing to deliver the first 21 million masks. So it failed to provide the masks on the 28th of April, 5th of May, 12th of May, and 19th of May. And one sees that in the core bundle at tab 26 at page 389. Where paragraph 5, it is admitted the delivery schedule for 26th April, 5th, 12th and 19th of May were not met. And it was accepted that that would be a breach of the supply contract subject to issues of affirmation when the schedule was revised. And the judge found the same in his judgment, which your Lordships should have at tab 16 of the core bundle. At page 198 in tab 16. At paragraph 161, it's clear that High-Tech's failed to meet the original delivery schedule, having missed making the deliveries due on 28th, 5th, 12th and 19th May, and that this represented a breach of the supply agreement as originally agreed. After that, there was a revised schedule which was agreed at about the 26th of May 2020, and your Lordships will see that agreement in writing or evidenced in writing at the supplementary bundle, tab 41. And if your Lordships go please to page 433, you can see an email from Mr. Stead. As per our telephone call, can you please confirm the agreed schedule for mask availability for this contract? And so what is being agreed is that the masks must be available on these dates. And there's the list with the revised dates. And your Lordships will again see it equals 80 million masks delivered. So again, these numbers are cumulative. And then if one goes to 432, the response is, sorry for the delay in replying as we're on holiday for the last days and today we resume working. However, kindly be noted the schedule below is agreed as discussed and according to the plan of receiving the new machines. So that becomes the new schedule. And a page 109A attached to our skeleton, if your lordships need it, there's a table showing the original dates and the revised dates next to each other.
So the fifth delivery was also going to be missed?
Yes.
The original fifth delivery?
Yes. And at the trial, High-Tech's argued that Uniserve thereafter failed to collect and pay for about 77 million masks, i.e. 80 million minus 3 million that have been delivered and paid for, and sought damages of around 23.1 million, i.e. Contract price for 77 million less some manufacturing costs. Uniserve denied liability because it argued that High-Tech's had failed to meet the delivery schedule both before and after the revised schedule, and that this amounted to repudiatory breaches of the contract. Although High-Tech's admitted it was in breach of the supply contract originally for failing to deliver the 21 million masks, it argued that Uniserve had waived those breaches or affirmed the supply contract and so lost the right to terminate. They argued in the alternative that Uniserve had failed properly to terminate the supply contract and denied liability in deceit or for misrepresentations. And it's important in understanding the first two grounds and the respondent's notice to appreciate that the claim for damages made by High-Tech's was under Section 50 of the Sale of Goods Act on the basis of 77 million masks, but not on the basis that they had accepted an anticipatory breach. On the contrary, their position was that they continued to perform the contract and were entitled to the 77 million under that contract. And in the judgment handed down on the 4th of July, the judge, as I'll show you in a moment, rejected High-Tech's claim for damages under the supply contract as advanced by them. In simple terms, he held, if you continue to keep the contract open, you must perform it, and you were not in a position to do so. You didn't have masks available to provide 77 million masks. Instead, he concluded that High-Tech's claim for damages succeeded on a basis which, it is common ground before your lordships, was not pleaded or advanced at the trial by any party, namely that High-Tech's purported acceptance of a renunciatory breach by Uniserve. That case was not pleaded, was not advanced at any stage by either party, was not raised by the judge in argument, and was not raised by the judge before he handed down judgment. And High-Tech's accept that is the position. They are not seeking to uphold the judgment on the basis found by the judge, then to pose ground one on the basis that he did deal with these or they were raised, nor do they say he was right to reach the conclusion he did. Their position, as your lordships will have seen from their respondent's notice, is that he was wrong to reject their case as to how damages should be calculated. And that is the basis of their respondent's notice.
Well, I say one question that occurred to me was, well, what would the answer to the judge's analysis have been if he had raised it? You have a position where Uniserve make clear that so far as they're concerned, everything is finished. They want nothing more to do with high-techs, and high-techs do not say anything to indicate that they think the contract is still alive for performance, and do not say to Uniserve at any stage, well, the next delivery is available now, come and get it. Anyway, you might want to.
I will.
deal with that.
I am going to deal with that, and I'll do this in due course rather than now. If
Of
that's
course.
okay. But yes, don't worry. It's in my notes to deal with it. It's not one of those ones.
But I understand fully that that's not the way that high-techs put the point below. The judge didn't raise it, and it's not the way that high-techs put it on appeal either.
No,
I was just curious about it.
I understand that, and funnily enough, this morning I thought your lordship might be, and therefore I intend to deal with it. Though, of course, one of the difficulties is the way the judge deals with the point is to look at internally the manufacturing. We will look at it, but he says they had stopped manufacturing, and that is the basis which he finds that in effect they've accepted the repudiation. But of course that's internal.
Well, it's got to be an objective analysis. I follow that.
Yeah.
Anyway, get there when you.
I will do, but I will do, and
Of course.
it is an interesting point, subject to the point that it's still not argued before your lordships either.
So you're going through explaining to us the background. Can I ask your help on page 87, the schedule of original and revised dates? And the last two columns are alleged delivery dates and alleged collection by Uniserve. It's not sure what the status of those two columns are. Is that alleged by high-techs? And what was the finding?
Yes, it was alleged by high-techs at the trial. Yes, alleged by high-techs.
And what's your position? You dispute it.
What's my position?
You dispute it, do you?
Yes. So no, we don't. This is what happened. They were collected. So I'm told.
So we can strike out alleged.
Yes, strike out alleged.
So does that mean that the delivery date is the date on which it was made available for collection, and the alleged collection by Uniserve column is the date on which it was then actually collected?
Whatever it was made available, what's their case? So, my lord, the position is that your lordship can strike out alleged in the final column, because that is our case that they were collected. But the alleged delivery dates is high-tech's case that we don't accept.
And that's based upon some form of tender.
Yes, yes. That's as I understand it.
So it's not alleged that there was a tender at any point after the 14th of June.
That's correct. And the judge found that there were no tenders for the 4 weeks before the 13th of July.
So what's the reference to that last? Judge found that there was no
Yes, if you
tender for 4 weeks before the 13th of July.
yes, I'll find the reference for you, if your lordship will just bear with me 1 second. It's If your lordship goes to tab 16, page 236, paragraph 401, the last sentence. By the 13th of July, High-Techs have made no attempts to arrange the pickup of 4 weekly deliveries that have become due. That is part of his reasoning as to why he then finds it was terminated on about the 13th.
High-Techs have made no attempt to arrange the pickup.
Yes, so they hadn't tendered them.
So that, in your case, is those are breaches that go to the roots of the contract. The time is of the essence.
Yes.
Do you say you accepted that?
Yes.
On the 11th of July?
Yes.
What's the answer to that?
I don't know.
What does the judge say the answer is?
He doesn't deal with the 11th of July. My ground 4 is that he doesn't really. He looks at the earlier position, and although he mentions in the course of argument the 11th of July, if I show your lordship, it's easier if you actually see the judgment as to.
Can you show us the 11th of July first?
Pardon?
Can you I'm sorry. Could you show us the 11th of July, where you terminated?
You mean the actual underlying document?
Yes.
I'll get that. I'll get that.
Stephen.
Yeah, of course.
Oh God. Sorry.
Yes, I thought that you terminated on the 17th of June and maintained a dignified silence thereafter.
No. Sorry,
got
if I
that
can
wrong.
have that reference. If you go please to the supplementary bundle, tab 45, page 437. Well, it looks as though on the 11th of July at the bottom, we haven't got the whole message, but what we've got suggests that High-Techs are certainly treating the contract as still alive at that stage. Yes. And then he comes back on the 11th and said that we've told you it's over. And the way the judge deals with this is, if one looks at the structure of the judgment, which I'll come back to when I get to ground 4, but since it's raised, if you look at the structure of the judgment, if one goes to 212, you can see heading 11, was there a failure to meet the revised schedule? And he then goes through for quite some pages dealing with that. The first issue was what was required of High-Techs following the agreement. And then 313, motivations, failure to supply to the revised schedule. And the evidence from Mr. Majdan, which is the telephone call. But then one goes on which he deals with it for many pages. But then the next big topic he deals with is at 224, which is the evidence from the production reports. And the oddity with this section of his judgment is, you can see if you go to 334, that he's looking at the production reports only up to the 14th of June.
334.
If you go to 224, paragraph 334, my lord, sorry. So page 225, paragraph 334, you'll see that he deals with the productions up to the 14th of June. And he then deals with criticisms of it, and then at 227, conclusions as to the breach of the revised schedule. But he's still looking at the early period. And then when he goes to, was there a termination of the supply contract? At 229, paragraph 353, you can see at 229.353, the communications relied on as providing a written termination are two emails sent by Dr. Stead to Mr. Carter on the 11th of July. They don't purport to be a termination notice. And then he at 361, says, ITEX argues there was no 361 at the bottom of page 230. ITEX argues there was no communication that was sufficiently clear to amount to a clear and unequivocal acceptance by Uniserve of a repudiatory breach, and it makes points based on the authority of Dr. Stead to effect the termination. I disagree, probably on the 17th of June, but certainly by the 11th of July, ITEX would have been, and I think it's established by internal emails was, in no doubt that Uniserve was purporting to treat the supply contract as being at an end as a result of High-Tech's alleged failure to make timely supplies. It's clear from Vittel that that would be enough for the acceptance of the repudiatory breach had there been one. However, there was no such repudiatory breach. And ground 4 of our appeal is that he's focused on the position up to the 17th of June, but did not separately consider and look at the 11th of July. Because his early looking at the production reports and what happened is all about what happened prior to the 17th of June.
So your position is that between the 17th of June and the 11th of July, further instalments fell due in accordance with the revised schedule and were not tendered for delivery. Is that the position?
1, that is the position, and 2, could not have been, for the other reason that he didn't take into account that it was clear common ground on the evidence that they had to retain 15% of anything they produced for the local market. And therefore, when he looked at the production figures, he didn't deduct 15%. So there simply weren't enough masks in any event.
But I mean, the 15% point is a separate.
It's a separate point.
But even disregarding that,
Even disregard.
you say no tender.
No
That's
tender.
that's the end of it.
Yes.
Okay.
If the
The
contract.
email exchange of the 11th of July, High-Tech seemed to be saying, we heard nothing from your agent since they came on the 14th of June. We will continue to make the stock, but you have missed the collections, and that's then the 3 collections.
Yes.
Those are the 3 dates. And then they seem to make the point that you have to make payment first, but that's not a term of the contract.
No.
So the point seems to be, they seem to be simply saying, we've made the stock, but you haven't collected them.
Yes.
But there were no tenders, as the judge found.
Yes.
So you were entitled, therefore, to terminate because time was of the essence of each of those.
Yes. Yes. Sorry, we've sort of jumped into parts of round 4, but yes, that's right.
Well, if there's no answer to that, then there's...
Well, there's no answer to ground 1 or 2 either. I mean, there's no answer to the fact that the judge has found this case on a basis that nobody argued. And he'd rejected all of their case. And there's no real answer to that in my respectful submission, because the respondents noticed, and the judge was right that their
No,
case
but the
doesn't
point
work.
about, forgive me, but the point about what happened on whether they, this is very much a prior question. And if they were in repudiatory breach on those 3 dates, and we don't get to, and you accept it, we don't get to any of this analysis that ground one's addressing.
No, that's true. But the judge found that they did not tender for the 4 previous shipments.
That's paragraph 401.
The paragraph I showed my lord, yes.
So, just to be absolutely clear about this, it seems he has found that they didn't tender on those dates, and he seems to have found the 11th of July exchange would have been an acceptance of repudiation.
Yes, but he doesn't. Yes, but he
So
doesn't.
that seems to be a complete.
Well,
That seems to be a complete finding of acceptance of those repudiatory breaches.
Well, that's what he's found. But the problem was that where he seems to have gone wrong was he analysed the position only up to the middle of June. He seems to have.
No, it's not right, because he has analysed that they missed those.
Sorry, but I mean when he was.
He has found on the 11th of July what you did would have. And it seems I'm not quite sure how on those findings he doesn't find that you accepted the repudiation on the 11th of July.
Well, I respectfully agree.
You might.
Well,
Is it a question of on whom is the onus? So is the onus on Hightex to say we've got the stuff, come and get it, or is the onus on Uniserve, knowing that there is a scheduled delivery on a particular date, to go and collect it without needing to be told whether it's there or not?
but if it's an ex-delivery, the position under an ex-delivery is you have to make them available, and you have to tell your buyer that they are available. There's nothing in the contract.
That's section 29.4 of the Sale of Goods.
Correct. It's the obligation on the buyer is to accept and pay for goods that are delivered or tendered. If you simply keep quiet, that is not a tender. I mean, I was trying to, in response to your lordship, all I was trying to explain was how the judge seems to have gone wrong, which is that although he talks about the 11th of July, and although he has made that finding, he seems to have been focusing, when one looks earlier in the judgment, at the position at earlier dates. Well, it's not going to take me very long when I get to ground 4 to go back over that. And there's that point, and then there's the 15% point.
Yeah. Okay.
So, in order to explain ground 1, we can pick up, in fact, at 362. Page 231, paragraph 362 of the judgment. So he found that there was no repudiatory breach. So therefore, of course, that would mean Uniserve's communication of the purported acceptance of that breach did not have the effect of accepting a breach. Instead, it must be regarded as an anticipatory breach on the part of Uniserve. Through these calls and emails, and through its ensuring action in cutting off communication with Hightex and instructing Mr. Magin not to collect any further orders, Uniserve made it clear that it was renunciating and refusing to honour its obligations under the supply contract, and no longer intended to be bound by its provisions. This renunciation amounted to an anticipatory breach by Uniserve. So he's found that there's an anticipatory breach. And then he puts a new heading, was there a termination by Hightex? And the problem with that heading is that was no one's case. Because if you look at, he says at 361, this anticipatory breach by Uniserve entitled Hightex to accept this breach as terminating the supply contract or to affirm the supply contract. Hightex didn't expressly in writing or in oral communications tell Uniserve whether it was accepting that the contract was at an end or whether it was affirming the contract. Necessary, therefore, to consider its conduct in determining what was the consequences of Uniserve's renunciation of the supply contract. And then he sets out what Hightex's case was.
I mean, if he's just pausing there, if he's talking about the 17th June, he's wrong, isn't he? Because we've seen the email of the 11th of July, which Hightex made clear that the contract is still alive.
Yes.
So he must be focusing on the position after the 11th of July.
Correct.
Presumably.
Correct. Well, and one can, yes, he must be, logically. But the difficulty is, at 363, Hightex's case is that Hightex didn't accept Uniserve's renunciation of the contract and continued to perform the contract. And going back to the discussion we just had, one can see that in the email at the bottom, that they weren't purporting to accept certainly renunciation on the 11th of July. They were purporting to perform the contract. But the case that Hightex argued before the judge is that Hightex didn't accept the renunciation and continued to perform the contract. And the way that the case was put, which is still the way that it's put in the respondent's notice, is Mr. Lewis and Mr. Knight argue that Hightex kept a sufficient quantity of goods to meet each delivery as it fell due, and therefore was meeting its requirements under the supply agreement. They argue that Uniserve's failure to collect is to be taken as an implied request by Uniserve to postpone delivery of the goods by instalment. Their argument is that as no period of instalment was stipulated, Uniserve could have given notice to Hightex fixing a reasonable time thereafter within which the goods were to be delivered and accepted. But Hightex could not be compelled to deliver at one time the whole quantity of the goods which, but for the postponement, should have been delivered in the period of postponement. This argument, in my view, is unrealistic and on odds with the proper interpretation of the contract. And his reasons, one goes over the page at 232, you can see at paragraph 372, he says that this was not a severable contract. 373, the supply contract made time of the essence. And then he deals with what's called the retendering argument. Mr. Lewis and Mr. Knight support their argument that Hightex continued at all times to meet its obligations.
So where are you reading from?
Sorry, at bottom of 323, page 323, paragraph 376. Mr. Lewis and Mr. Knight support their argument that Hightex continued at all times to meet its obligations under the supply contract, with the proposition that Hightex could recycle, or as they prefer to put it, retender deliveries. If 3 masks are due on one date and Uniserve doesn't collect them on that date, Hightex can proffer the same 3 million masks to meet a requirement to provide 3 million masks at a later date. And then he refers to the cases that they cited. And at 3, he rejects the cases in the recycling argument. And at 234, at paragraph 385, he says, with this jurisprudence in mind, I turn again to the construction of the supply contract. I see nothing in the supply contract that suggests that if Uniserve failed to collect a delivery on time and then turn up later to collect that delivery and a subsequent delivery is then due, Hightex can provide the subsequent delivery using the stock it had manufactured for the first delivery and should be given extra time to manufacture further stock to meet the second delivery. In my view, if Hightex was seeking to continue to perform the supply contract after Uniserve's renunciation of the contract, it would have been required to continue accumulating stock to meet the cumulative totals outstanding according to the revised schedule. It's clear that after a period, Hightex didn't continue to do this.
And you say, presumably, that he's right about right about his conclusion in 385 and 386, and he should have stopped there.
Correct. He is right about it, because you can't possibly, under a contract for 80 million, keep retendering the same 5 million and say that's an 80 million contract.
And that's the respondent's notice point.
Yes, and I'll come on to a bit more detail on that. But that is, so I say he's right, and he should have stopped there. I had a debate at the application for permission when he asked, well, the difficulty is when you're writing the judgment and you don't think either case is right, you have to do the best you can. And my submission in response is you either keep to the parties' pleaded cases, or if you think there's a point that's been missed, you invite further submissions, which often does happen. But he didn't do that. And of course, the problem is that then feeds into his calculation of the damages, because he has now he then goes on to analyse and
No, just be clear about one thing.
Yes, of course.
You obviously got this judgment in draft. Did anybody make the point to the judge who received the draft judgment that he decided the case, that he was proposing to decide the case on a basis that nobody had argued, and at that stage suggest to him that he ought to hear some further submission? Or was the point that he made to him after he'd handed it down?
so the draft judgment contained a serious problem with the figures. All the maths was wrong. And we went back to him on all of the maths and we made that point, but we did not make the point that he had decided when we saw the draft on a point that hadn't been argued. No. It was done when he handed it down and at the permission stage.
How long a gap was there between between draft and hand down?
I think it was about a week. I was instructed a few days before the permission hearing, and there was a big debate internally about what we should do about all the figures being wrong. And I took the view that it was right to tell him that. But where a judge decided on a basis not argued, we thought that that was the sort of point that was not a slip, and therefore was not appropriate to draw the judge's attention to. It may have been wrong, but that's the view I took, because normally there's lots of arguments that you should have done with this and you should have done that.
I mean, it would be useful to know when the judgment was circulated in draft, because if both sides agree that the judge has decided the case on a basis that neither of them argued, or as it were, the judge could decide it, but only after hearing further submission, I mean, that is the appropriate time to tell the judge before he hands down his judgment and it becomes too late.
But
Or at least arguably too late at that stage. I mean, I'm not even sure it's technically too late at that stage unless he's actually made an order.
Well, when this point was then raised in front of the judge and invited Mr. Lewis to comment, Mr. Lewis said he wasn't in a position to comment. He'd been on holiday. The judgment, I think that's fair to say. There were no, at that stage, it wasn't accepted that he should give permission. And it wasn't accepted that he got it wrong when we were arguing in front of the judge.
It looks as if the chronology is that you got the draft judgment probably about a week before the 4th of July. It was then handed down on the 4th of July.
Yes.
And then you had the permission hearing and other consequences on the 17th of July.
That's correct.
Yeah.
But between the two, there were a lot of amendments relating to all the figures.
And you're telling us it was not accepted at the 17th of July hearing that the judge had decided the point on a point which was not.
So the judge invited Mr. Lewis to comment on my point that he decided on the basis, and he said he was not in a position to make any submissions on the topic because he'd been on holiday.
Fair enough.
And I don't know if your lordships, I can show your lordships, that the judge refused permission on the point. we go please to the core bundle at tab 20. At page 334. He says, to explain how this issue, so this is ground one, which is the same point. The defendant pleaded it had purported to terminate and clearly was not accepting further deliveries. I didn't find a lawful termination by the defendant on those grounds. This point reflected the claimant's argument and was addressed in pleadings. The claimant's further argument was based on the contention it was continuing to perform, as it already had enough masks to meet any single delivery. But I found this to be wrong in law once it got to the position where it was failing to keep the full entry necessary to provide the entire number of masks which it was due to perform. Neither side's pleadings or arguments met the facts as I had found them to be. It was therefore necessary for me to look at what had happened and interpret the facts as I found them to be, and in circumstances where I do not think there was a substantial difference between the parties on what the facts were. Neither side pleaded that there was any actual communication between the parties after the defendant reported termination. It was necessary, therefore, for me to place an interpretation on the actions having regard to the facts that I had found. I remain of the view that this was a correct finding of fact based on the facts before the court. It has been suggested that I have, in these circumstances, asked the parties for I should have, in these circumstances, asked the parties for further representations or to reconsider their pleadings on the ground that they had not dealt with the position that I had found to be the correct position, and I can see some force in this. Whilst I remain of the view that this was a correct finding of fact based on the facts before the court, I can see that there may have been in this a procedural unfairness, and the Court of Appeal may wish to re-examine that and to allow further opportunity for the parties to consider the position in the light of my findings. That might offer a prospect of success for the defendant on this ground of appeal. However, even when there's a real prospect of success, the judge has a discretion to refuse permission to appeal, and I consider I should do so in relation to this ground on the basis that the claimants have not had a proper opportunity to make representations on the point, and I have not had time to consider the point in any great detail on this matter. And your lordships can cross-reference that to Core Bundle tab 19 at page 303.
And by this stage, the order was made on hand down.
Yes.
So it's too late to do anything about it under the barrel jurisdiction.
Yes, but the difficulty is it was not, and it still is not, my learned friend's case that this is what the right answer should be. So his...
Yeah, but
yes.
so the point when I raised this, it's that, as I understand it, if both sides in front of us agree that ground one succeeds, because the judge shouldn't have decided the case on the basis that it was not being advanced by either side, at least without giving the parties the opportunity to address argument on the way he saw the case.
Yes.
And I'm just trying to get to the bottom of whether an opportunity was missed to draw that to the attention of the judge. And at the moment, and I'm not being critical, I'm just saying, in the ideal world, if that's what the judge did, the time for the judge to have that drawn to his attention is when the draft judgment is produced, before either it's handed down, or ideally, or even after it's handed down, before the order is perfected.
Well, my lord, if the criticism is that we should have done that,
I said I'm just trying to make sure I understand. That's my understanding of how procedurally these things can be addressed.
Well,
Maybe that others disagree or agree, but that's certainly how I would understand these things could be addressed.
Well, there was an opportunity to see the draft judgment. The opportunity was missed if it was an opportunity to draw that to the judge's attention. If it was a mistake, I apologise, because I took the view that that was more than correcting typographical errors, and I have seen many judges get very cross when one says, well, you've missed this point and you haven't done this point. Because part of the problem, of course, is if that had happened, neither party was saying he was right. And that would have meant, of course, the high techs would have lost on, after all, they wouldn't have had their respondent's notice. And they would have just lost. And it's a very, it is very, I mean, the court may think that it is appropriate for people to draw it to the judge's attention that he either missed points or failed to deal with points. In the course of this appeal, of course, we say he dealt with a point that wasn't argued. He also failed to deal properly with points that were argued, such as the 11th of July. We also say in the context of the representation argument. We also say it in the context of clause 26.4 and the waiver argument or affirmation argument. It is very difficult when one sees a draft judgment to know how one deals with what people have missed or not argued.
Well, you're going to get a pretty dusty answer from most judges if you send a long list of points not dealt with or dealt with wrongly like
Yes,
that.
Exactly. And of course, if both parties had agreed when reading the draft that the judgment could not stand, I can see that might be different. But that wasn't the position here. There was no agreement at that stage.
Well, you've drawn our attention to the fact that Mr. Lewis was not in a position to comment even at the 17th July hearing, because he'd not been away and not had a chance to read it all enough. And effectively, the judge says, "Can you help me, or am I on my own?" And the answer is, "Sorry, mate, you're on your own." Well, not put so crudely, of course, but the "you're on your own" was put.
Yes. I did try and assist when he asked me, what does one do in those circumstances? And one of the oddities is that the judge raised, what does one do when one reaches the conclusion in writing a judgment that you don't accept either party's position? And there are two things you can do. One, you can strictly keep the parties to the position they're in and find, I don't accept either party's case, and therefore the person with the burden of proof loses. Or you could call for further argument.
Can you just check when the draft was circulated?
Yes.
At some point.
I will tell your lordship. We'll get that checked, and I'll tell your lordship. Yes.
Can I just go back to paragraph 401 of the judgment, page 236? Forgive me, I may be a bit slow about this, but I think one was looking at this from the point of view of a finding that there was effectively no tender of those 4 deliveries. Not sure it was 4, but looking at it again, I now see what the judge is in fact dealing with there is that he is regarding the no attempt to arrange the pickup as part and parcel of the acceptance of repudiation.
Correct. And coming back, I was holding back on that one. What is the right answer to this case? In my submission, the right answer is if they have not terminated the contract and are under an obligation to continue supplying and fail to do so, they are in repudiatory breach.
And before they terminated, you terminated.
Correct.
On the 11th of July.
Yes. We say it's very similar to the position in the Semena. You know, if you don't, it was, I think it's the Semena, I'm going to show you in a minute, the Charter Party cancellation case, where someone purports to cancel too early, it's not accepted, and then they can rely on the later cancellation right. So here, the correct answer is if they said we are still maintaining, they affirm the contract and perform the contract and simply fail to deliver, then that's a breach.
So just to be clear, there's no non-tender between the 11th of July and the 13th of July.
No non-tender.
There was no delivery due between the 11th and the 13th.
There was one due on the 12th.
There was one due on the 12th.
If your lordship would just bear with me, I can check that.
Yes, there was.
Yes.
And one due on the 13th.
Yes.
But my understanding, you say, there were, under the revised schedule, delivery dates due in the 21st, 28th of June and the 5th of July, and no arrangements made by High-Tech to say, come and get your goods.
Yes. And the judge.
And you, so a little earlier on, you said there's a, show my ignorance of the Sale of Goods Act here, which isn't in the bundle, curiously. But there's a section in the Sale of Goods Act which you say mandates the requirement for delivery in terms of the seller notifying the buyer that the goods are available for collection, saying effectively come and get them.
No, what I referred to, and I'll get that and put that in the bundle for you, is section 27, which is it's the duty of the seller to deliver the goods and of the buyer to accept and pay.
Yes.
That was the section I was referring to.
Right, and you rely on that as not having been done in this case.
Yes, because
you say delivery means contact and notify they are available for collection, X works, come and get them.
make the goods available. You can't make the goods available unless you tell them that they are available.
Right, so you say the onus is on the seller to do that.
Yes.
And the failure to do that was the breach.
Yes.
And was that point made to the judge in terms?
I wasn't at the trial, which is why I looked.
No, I understand that, but I'm not eager. But that unpacking of what delivery involves, with the consequence you say it's a breach that's not capable of remedy, was that made clear to the judge? Is what I'm asking.
I think Mr. Walsh wants to check before he formally answers that, but we will check.
It doesn't feature in his judgment, from memory.
No.
That analysis is clear, certainly not as clearly as you have now put it.
Correct. As I read the judgment, the issue seemed to be what masks were actually available at various times.
I'm just trying to, again, see it from the perspective of what was put to the judge and why it's not in his judgment. Because if you're now effectively saying that was
I agree.
the answer the judge should have come to, it's at least useful to know whether that answer was suggested to him clearly or not into the hearing.
I respectfully agree, and I'll ask Mr. Walsh to check that. I don't want to say the right until I've checked it. But of course, what I'm on at the moment is the judge deciding something that wasn't put at all by anybody. What he seemed to do, if we go to again that paragraph 402.
I understand you say you can criticise him for deciding on a basis that wasn't put to him, but I'm just trying to check that, as it were, you're not now saying that we should say he should have decided on a basis which also wasn't put to him.
No, but I'm not suggesting. Yeah, I understand that, obviously. I understand that, and obviously I'll understand that.
The best you get from the Act as to what delivery entails in this regard is the rules about delivery in section 29.
Yes.
And subsection 5 says demand for delivery or tender of delivery may be treated as ineffectual unless made at a reasonable hour. Which seems to make it plain that you tender for delivery.
But you would have to, wouldn't you? I mean, if you think about just thinking about the facts of this case, if you have a factory that is making masks, it would have to say to its buyer, I now have 5 million masks available for you. That's the tender.
Well, you could say that the provisions in the schedule are a tender, in that they're saying the contractual term is that they will be that they will be delivered on the date in the schedule. And so why can't the buyer turn up and say, where are my masks?
He could do that, but this is an ex-works contract where the seller is obliged to supply the goods ex-works, which means he must have them physically available and tell the buyer that they are available. And that fits in with section 20.
The second of those two limbs, I think, with this question. I mean, the first limb is obvious. The second is the one that I would be certainly personally assisted by some clear authority or otherwise on that point.
Yes, well, one of the problems with ex-works, and we couldn't find a clear authority that deals with this point. I mean, the wording that I found in Benjamin is the seller delivers the goods when it puts the goods at the buyer's disposal at the factory. I don't think that really answers your Lordship's point as to any authorities on this point. I haven't been able to find a case that makes that absolutely clear. But my submission is if you go back to section 29 and think about what has to happen, it must be that the buyer must tender the goods or identify them and say they're available to collection. And if you look at the whole form of the contract, it's talking about the onus on the buyer to supply the goods. There's nothing. The seller to supply the goods. There's nothing in the wording of the contract that says that before he must supply the goods, the buyer must do something.
Well, but the seller can't supply the goods unless the buyer is there to take them.
But he can tender them. And if he's asking for the price.
Is there anything, perhaps you might have a look in Incoterms or any of those?
So I looked at Incoterms on ex-works, and again, it talks in terms of making available. There's nothing, I had a look at that this morning, the Incoterms. And again, that doesn't really assist you on this specific point. It talks very in general terms. I mean, if you like, I'll photocopy the section of Incoterms as well. It's quite short, but it doesn't really assist.
It might not help very much.
I did check that because I thought that might be an area that would be useful. I'm afraid that doesn't really help you. I think I need to read it properly before I answer your Lordship's question.
Just out of interest, did the judge have a list of issues?
He did, but the list of issues is not very helpful. It's quite short and very high level.
Right, so this particular, we're drilling down into this particular issue, but certainly the list of issues wouldn't have identified this debate we've just been having.
No, not at all. It was at a very high level. And there's always a debate about how detailed the list of issues should be for a judge. But in this case, it was certainly not granular.
Well, the judge did list issues at paragraph 17.
He did. And one of the oddities of that list is, although he talks about at 17.5, did Uniserve terminates the contracts, there isn't an issue, did Hightex terminate the contracts?
No, but he should have, under 17.4, was Hightex in breach of its revised delivery obligations. I mean, that should have thrown up this question, should it not, that we've just been debating?
Yes, but that's why I'm slightly hesitant. Yes, is the answer.
Yeah.
But
I know you say it's high level, but that's where this debate that we've just been having fits.
Yes, but I don't. From what I haven't read everything, but from the transcripts I've read, there was no detailed analysis along the lines that your Lordships have been asking me. I don't think it was. I think to be fair to the judge, I don't think it. From what I've seen so far, and I'll check, I don't think there was that sort of focus. Yeah, the last sort of point on this part of ground one was I was making the point that his finding also feeds into his analysis of the damages. Because he has found at page 236 at paragraph 402 that the supply contract was terminated on around the 13th of July. And therefore, the questions that he asks at page 238, paragraph 413, in little one is, was there a market in mid-July that High-Techs could reasonably be expected to be able to access for a contract to acquire 77 million masks on about the dates provided for in the revised schedule? And he finds that there is a market, and at 449 he says, having found there was a market, I'm obliged to make a determination as to what the market or current price is, and he finds 8 cents per mask at 4.50. But of course what he's doing is finding a market for the total quantity of 77 million as at the date he's found the breach of the 13th of July. So his finding as to the date of termination also feeds into his calculation of damages, because he basically gives loss of bargain on 77 million on a market price, contract price less market price, that he's looked at the 13th of July. And one of the difficulties that he had, of course, was that the experts had not been asked to consider that question because it wasn't an issue in the case. My learned friend's case was that they continued to perform the contract and so were entitled to 77 million masks worth of damages, and that there was no market. The Uniserve's expert position was that there was a market, but that of course it changed during the course of the pandemic. And if you look at page 242 of paragraph 439, you can see that she found, or her expert opinion was that it was 11 pence for May deliveries, 45 pence for June deliveries, because of course that was the height of the pandemic, and then 11 pence thereafter.
Sorry, this was whose expert?
This was our expert.
Your expert.
High-Tech's expert's position was there was no market and I can't give you a price. Our expert's was there was a market and this is the market on particular dates. The judge, however, was looking for the position as at the 13th of July. He found that there was a market, and doing the best he could, he concluded the market price was 8 cents. So his finding on acceptance of an anticipatory breach goes not just to sort of liability, but how he calculated the damages. And none of that, of course, was argued in that way. So in my submission, the position is, as Lord Justice Mail said, having concluded that High-Tech's position was wrong, he should have stopped there, which means they would have lost. And it's accepted by High-Tech's that he was wrong to do what he did. As they say in their skeleton argument at tab 11, page 121, High-Tech's accepts that the judge's analysis that High-Tech's had effectively accepted Uniserve's repudiatory breach was neither pleaded nor argued before him, and his relevant conclusion wasn't open to him, the judge could and should have invited submissions and amendments of the pleadings if necessary, even at a late stage after the conclusion of evidence. And 13, high-tech's principal cases, the order should be upheld on the grounds the alleged judge was wrong, and then that's the respondent's notice. And they also accept in paragraph 5 at page 120 that ground 2 essentially flows from ground 1. Because ground 2 is that he shouldn't have made the findings that he did on damages. And of course, that flows, as I've just shown, from his findings under ground 1. So we submit that the starting point for your lordships is that it's common ground that we should succeed on grounds 1 and 2. Then we need to look at the respondent's notice. And of course, there's no cross appeal as such. And it isn't a case where the high-techs is saying his judgment should be upheld but on slightly different grounds. And what they're saying is that he was wrong to find against them. That he should have accepted their case that the contract remained open, and their case that they can retender the same goods multiple times, and therefore their case that they're entitled to damages based on 77 million for the course of the contract. Which
They don't have permission for the cross appeal.
They don't have a permission for cross appeal. They never asked for permission for cross appeal. But it is not a case where this is a true respondent's notice. This is a true cross appeal. Their case was rejected by the judge.
But they're not saying it leads to a different order. I mean, the analysis might be slightly different because on the judge's analysis, high-techs are going out into the market to make a forward contract for 77 million in the middle of July, whereas on high-tech's pleaded case, they are, in theory, going out into the market on a number of different occasions as and when deliveries fall due.
And therefore it's a different basis, so the figures might be different.
Well, trying to dump 77 million on the market all at once would depress the market price and increase the damages, wouldn't they?
But then as we come to the respondent's notice, on this basis the contract is open and for performance, and they don't have 77 million masks. The total number that they ever manufactured was 20 million. So, and this is the...
Well, this only works if the retendering or recycling analysis, which the judge rejected, works.
Correct. But that's why it's... yes. But then you would be doing a hypothetical analysis of, I'm not quite sure what, presumably it would be the market value at the date when each instalment should have been accepted by Uniserve. Because on this hypothesis, if retendering or recycling works, then it would be, presumably, the contract is never terminated. They're entitled to retender the same goods over and over again, and the damages keep going up on different dates. That's why I say this isn't a true respondent's notice at all, it's a cross appeal.
Well, sorry, can you just help me with that? How do they cross? I mean, they've got judgment in their favour. How do they cross appeal?
Because well, I'm going to deal with
the... You appeal against orders, not against reasoning. How do they cross appeal?
Well, they cross appeal on the basis that the judgment is incorrect on how it calculates their damages.
But all the order says is there be judgment for the first claimant on its claim.
Yeah, I mean, they're happy with that.
And they say, yes, please.
I've made the point. I'm going to deal with the merits of it.
I was going to say, I think...
I'm not going to
raise myself. I think we need to deal with the substance.
I'm dealing with the substance.
I'm struggling at the moment to see how they appeal that order.
Well, fine. I said I'm going to deal with the points, and it's in front of your lordship, so I think I'm going to deal with it. So, this is... The respondent's notice is at tab 10, page 112. And what they say is the learned judge was wrong to find that the first claimant was obliged to maintain sufficient stock to fulfil all deliveries that had fallen due, notwithstanding the defendant had failed and refused to accept such deliveries, and or was not entitled to retender goods in mitigation of its loss. So that's the basis of the respondent's notice, and as I've shown you, Lordships, is pretty much the same as the submissions that were made to the judge at trial, that he rejects. And the key point we say is where a seller delivers or purports to deliver goods pursuant to a contract and the buyer refuses to take them, or the buyer is guilty of an anticipatory breach, the seller has a choice. The seller can accept the buyer's breach and therefore terminate the contract and claim damages for loss of bargain under Section 50 of the Sale of Goods Act based on the difference between contract and market price. And where there is a market, that will be the prima facie measure of damages under Section 50, subsection 3. Alternatively, the seller can affirm the contract or keep the contract open. It can continue manufacturing or procuring the goods and tender or make available for delivery those goods and claim Section 50 damages on each date that the seller fails to accept those goods. And again, if there's an available market, the prima facie loss under Section 50, subsection 3 will be the difference between the contract and the market price at the date of each of those instalments or failure to accept delivery. There is no third way. You cannot keep the contract open and say that because of the anticipatory breach, you are excused from complying with your obligations under the contract. The position here is that Hightex did not accept any repudiation to bring the contract to an end, but nor did it continue producing and tendering masks for redelivery so as to access Section 50 damages for each instalment that was not accepted. It cannot claim damages on the basis that it kept the contract alive, but then fail to meet its own obligations under the contract, which is to supply a total of 80 million masks. A seller who opts to keep a renounced or repudiated contract alive cannot then claim the price for goods which it never manufactured or tendered for delivery. And we say that those principles are encapsulated by Lord Ackner in the Simona, which your Lordships will find in the authorities bundle at tab 10. And as I mentioned in the course of argument, this was a charter party case where the charterer gave a notice of cancellation too soon, which was an anticipatory breach. But the owner did not accept that renunciation. And then when the time came for the correct notice of cancellation to be given, that was given, and that was held by the court to be successful. And just in passing, in the Court of Appeal, famous cliches like an accepted repudiation is a thing writ in water and of no value to anybody, it confers no legal rights of any sort, was referred to, and the principle that where the contract is affirmed by an innocent party, the position is simple. You either affirm the whole contract or rescind the whole contract. You can't approbate by affirming part of it and disaffirm the rest of it, because that would be a new contract. And Lord Ackner, if we go just to see what's happening, at page Authorities Bundle 248 in tab 10 and page 801 of the report, you can see the reference to the Braithwaite decision. And it was suggested that the Court of Appeal in Braithwaite took the position that you could somehow be excused performance without accepting a breach. And the oddity is that, in fact, Braithwaite at first instance was a case where the repudiation had been accepted, but the Master of the Rolls seemed to treat it as the opposite, and that was considered rather odd. And what Lord Ackner says at D is, I therefore conclude the decision in Braithwaite is not an authority for the proposition advanced by the appellants.
Sorry, I've lost.
Which page are you on for that?
I'm so sorry. It's Authorities 252 at page 805.
Yeah, I got Braithwaite, but 805.
Yes. Letter D.
Oh,
I
yeah.
beg your pardon.
Yep, that's fine.
I therefore conclude the decision in Braithwaite is not an authority for the proposition advanced by the appellant. Alternative it is, then it is wrong. When A wrongfully repudiates his contractual obligations in anticipation of the time for their performance, he presents the innocent party B with two choices. He might either affirm the contract by treating it as still in force, or may treat it as finally and conclusively discharged. There is no third choice as a sort of via media, to affirm the contract and yet to be absolved from tendering further performance, unless and until A gives reasonable notice that he is once again able and willing to perform. Such a choice would negate the contract being kept alive for the benefit of both parties, and would deny the party who unsuccessfully sought to rescind the right to take advantage of any supervening circumstance, which would justify him in declining to complete.
It's probably unduly pedantic to say that there are not two choices, but one choice between two courses of action.
You are absolutely right, my
But
lord.
anyway, that's the point.
But that is your lordship's right. But what this makes clear is there is no middle choice, that you affirm the contract, but that say, because of the breach, I am now excused performance myself. If you choose to affirm a contract for 80 million with various instalments to be given cumulatively, you yourself must perform those instalments if you are to claim damages. If you don't do that, then two things can happen. One, the party that was in breach or in renunciation may rely on the terms of the contract by supervening events, i.e. either a breach by the otherwise innocent party or frustration or so on. What you can't do is say, I no longer have to do what the contract told me I had to do because you were in breach. That's the basis of this authority. I'll come back to the other point that's made here, but just since it's open, Mr. Boyd sought to run an estoppel argument as an alternative, but that was rejected because it wasn't run below, and what is said at page 806, just below A, fifth line down. There is, however, no finding of such representation, let alone the owners were induced thereby not to make the vessel ready to load on the 9th of July. And I rely on that when we come back to my learned friend's estoppel argument. And my lords, what we submit in the light of the Simona is that when you then go back to the contract, which I showed you first thing this morning, it shows that Hitex's obligation is to supply the identified goods in the total quantity of 80 million in the different instalments. That's its obligation. If it chooses to affirm the contract and not bring it to an end, it must comply with its obligations before it can seek damages from the buyers.
Basically you say it's a cumulative obligation. That was why you emphasised that right at the very start.
Correct. course, when one looked at both the schedule in the supply contract and the amended schedule, both of them say equals 80 million. And that's why I say it's cumulative. And if it's cumulative, obviously you can't get a recycling argument off the ground, because the same 5 many times over does not equal 80.
But the point being, if you miss an instalment but make it up and then tender 2 in 1 on the next date, it has to be 2, double, whatever the double amount is.
Yes, if it's 2 lots of 5 million, yeah. It's not 1 lot of 5 million. And of course, one of the points the judge made was that under clause 5.1 of the terms of the contract, time is of the essence for the seller. It's not for the buyer. So the seller is obliged to hit each of the dates. The buyer is not actually obliged to pick it up on that date. So if the buyer was late, you couldn't possibly be retendering the same to the second one, because the buyer's got the right to pick up both of those instalments. That was the point the judge was making. And the other point that he was making is that it's not a severable contract. It's not where you treat each instalment as separate, because any one breach can give rise to terminate the contract, which means that the parties are treating this as one contract for a total of 80 million. So there's no basis on which you could recycle.
Well, if the contract's affirmed and at the end of it you say, please pay me damages for not taking 77 million masks, the basis of that is that you have performed and you have 77 million masks sitting there.
Yes, exactly. But that is, and that is the short point that was being made to the judge that the judge accepts. If at the end of this you are saying, I'm entitled to damages for 77 million, it has to be on the premise that you have performed and provided 77 million.
And if at some point that becomes onerous to you, the answer is to accept the repudiation and claim damages on that basis.
Yes. Correct. But what you can't do is say, well, I've only made 15 million, but I'd like damages for 77 million. Because then that's not performing your side of the contract. And that's the reason why you have to choose. Do you affirm or do you accept the repudiation or renunciation? And so that is why we say the judge was right to reject the recycling argument, both on the construction of the contract as a matter of first principles of damages, as a matter of the fact that the contract can't be treated as severable. And my learned friends in their submissions to the judge relied on 3 cases which he rejected. They are not relying on those 3 cases before your lordships. Those are not in the bundle and they're not in their skeleton argument. So there is no authority, and there's nothing in the textbooks to suggest that where a contract remains open, you are entitled to recycle the same instalment multiple times. And if just stepping back, common sense suggests, as your lordship said, if you are claiming damages for 77 million, you must show, if the contract stayed open, that you have 77 million, because that's the bargain you've lost. The only case that is tangentially, and I accept it turns probably on its own fact, is the Stochner case, which the judge referred to. And your lordships will find that in tab 12 of the bundle. It's the case of 6 shipbuilding contracts. And of course, in a shipbuilding contract, one of the important stages to get money is keel laying, which always sounds rather exciting, but is actually just welding 2 blocks together, and that is called the keel laying. And that triggers normally an instalment under a contract. And what happened here was the yard effectively did keel laying for 2 contracts, but wanted to keep retendering those 2 for the subsequent contracts 3 to 6. And it was held that they couldn't do that. And Lord Gough, which your lordships find his opinion starting at the authorities at page 272, he then says at 277 at page 581, letter H, at first sight it seems surprising that the yard should be entitled to proceed in this way under contracts 3 to 6, i.e. the retendering. How can it be right, the buyers ask, that the keels constructed for contracts 1 and 2 could, so to speak, be used again to trigger further instalments under 4 other contracts before finally being incorporated into the ships built for Lorient Maritime? So just pausing there, the reference to Lorient Maritime is that what eventually happened is, having tendered keels 1 and 2 for contracts 3 to 6, they then proceeded to build ships and sell that on to Lorient in mitigation. So they wanted 6 lots of instalments plus their mitigation. This question calls for an answer, though it's fair to comment that the adverse reaction intended to be provoked by the question is likely to stem more from the repetitive use of the keels in circumstances in which it was known that the buyers were unable to pay for any of the vessels than for the simple fact of reusing a keel for a second vessel to be built under identical specification. And then he says, in fact, the problem falls to be solved by the ordinary process of construction of the relevant contract provisions. And that's why I say it's tangential relevance, because he then construes the particular contract and says, in effect, the keels had to be laid on a particular berth under that contract.
Masks are not masks are fungible goods, aren't they?
Yes. Yes. But he also deals with the mitigation argument at F, which again I'm going to come back to because my learned friends run a mitigation argument. I'm bound to say I do not find, at F, last sentence. Lastly, he claimed the reuse of the keels probably constituted fulfilment by the yard of its duty to mitigate its damage. I am bound to say I did not find Mr. Cordara's argument on mitigation persuasive. It could hardly be said that the incorporation by the yard of the keels for vessels 1 and 2 into vessels 3 and 4, and then into vessels 5 and 6 was done in exercise of the yard's duty to mitigate, when, as the yard knew, the buyers had already made it plain that they were unable to pay for any of the vessels. The yard's purpose was, of course, quite different. Mitigation didn't occur in this respect until the keys were incorporated into the vessels built for Lorient. And then Lord Lloyd, in his opinion, we can pick it up at page 297. And perhaps I could just invite your lordships to read the side panelled section, where he again is dealing with mitigation. So we say in this case, like Lord Gough, the answer is in the construction of the contract, that it's a cumulative number. But my learned friends run 2 arguments in their skeleton in addition. One is said to be a mitigation argument. And it's said that stopping manufacture in mid-July was somehow a mitigation. But if the contract is open, it's difficult to see what loss they could be mitigating. Having kept the contract alive, stopping manufacture can't mitigate the breaches that have already occurred. You can't mitigate in advance. So if you say, I stop manufacture to mitigate my loss, but I'm obliged tomorrow to tender these, I'm not mitigating that loss, because that breach hasn't happened yet if the contract is still alive. It's the problem with their mitigations, what loss that they say they're mitigating in a contract that is in instalments in the future? You can't be mitigating that loss. You can only mitigate breaches that have already occurred. The duty to mitigate does not arise until there's been a breach. On this basis, on this analysis, if the contract had been kept open and say instalments 1, 2, 3 had been missed, stopping manufacturing for instalments 5, 6 and 7, which are not yet a breach, cannot mitigate what's already happened. That's the first problem. The second problem, of course, is if you think about the measure of damages for each instalment. So let's assume the position is that there was a breach of instalment 2 for 5 million. The measure of damages for that under the Sale of Goods Act, section 53, is to take the difference between the contract price and the market price at the dates those goods should have been accepted. The reason one does that is that it is assumed in mitigation of loss that someone will go into the market and sell those goods and therefore can claim the difference between the contract and the market price, i.e. what they would have got under the contract less what they deemed to have got in the market. And the law is that is the measure of damages as a matter of mitigation, whether you do it or not. If you choose not to do it, that remains the measure of damages. So the law is deeming that you have sold those goods in order to calculate the damage. If you have sold those goods in mitigation in order to calculate the damages, by definition, those goods cannot be available for the next instalment. So you can't retender.
I think Mr. Lewis says, well, if we'd sold them, we could have bought them back.
But he didn't do that, though. No. I mean, there's no if he'd done that, then we would have an interesting debate about whether you could do that. But he didn't. And the problem with his position is his case is always premised on, I kept the contract open. And what he's trying to do is then find a hypothetical way of calculating damages against a contract that is kept open.
So if time is not of the essence, it's not for the buyer, he can come along, as you say, when instalment 4 is due and ask for instalments 3, 2 and 1 as well.
Yes.
At what point do you say he has to mitigate?
Well, he only has to do what's reasonable. So if the position is the contract is open and he's not claiming damages for any of those, it's at the time it would normally be with the contract at some point you'd accept that there had been a repudiatory breach, and therefore you'd say.
Let's assume though that he lets it run all the way to the end.
Well, then he would never have to go out to mitigate until the end, because if the position is he can say, well, it's reasonable for me not to sell this. He can't retender them. He has to keep them till the end.
So it's only right at the end he can go into the market and mitigate his loss.
If that is the reasonable thing to do, yes. But you could take the alternative view that after a reasonable... I mean, normally, if time's not of the essence, you would make time of the essence by calling on someone to tender. So the position would be, in your lordship's example, say 3 or 4 instalments have gone past, then the seller would give notice making time of the essence. And at that point, he can then go into the market.
But only if he accepts the repudiation.
Yes. But if he chooses not to, and he keeps it open, then he has to keep manufacturing and keep tendering until the end.
If he makes time of the essence and the buyer fails to take delivery by the deadline, is the seller's course then, is he entitled to terminate simply in respect of that delivery, if that's what he wants to do, or does he have to terminate for the whole non-severable contract?
If it's a non-severable contract, he would have to terminate for the whole contract.
Well, the judge said it was.
He said yes, exactly. So the answer, I was just thinking it through. The answer is yes, Your Lordship's right. He would have to terminate the whole contract.
So even on that basis, retendering wouldn't operate.
Correct.
Whereas if it was severable and you simply terminate for that delivery, at least retendering's got more of a run.
Yes, and of course, as we know in the facts, that's not what happened.
No.
And that is why the judge dealt with the severability argument. So, well, even in those circumstances, there's something odd about the idea that you can terminate for that instalment and then retender, as opposed to if you've terminated for that instalment, triggering the section 53 damages, i.e. going out into the market to sell. Which is why, even if it was severable, I would submit that the recycling still wouldn't work. So the position we submit on that is, on their own figures, they never manufactured more than about 20.5 million masks. They never manufactured more than that. They only had material to make 40 million masks. And the evidence at the trial was that, in fact, they sold the masks they had into the local market, though there's no evidence as to when, to whom, and for what price. But we've set that out in our skeleton. So that in fact, they never did retender. They didn't have the material to retender. And we submit, therefore, their mitigation argument doesn't work. And the only other argument that my learned friend now raises is a Stockel argument, which is, in effect, the same argument raised by Mr. Boyd in the Simona. And we say fails for the same reasons, because this is not an argument, as far as I could see, that was pleaded. There's no Stockel. It's not an argument that was run below. And there was no finding by the judge of a representation, let alone of reliance, which is the reasons why it failed in the Simona. There's no evidence that, and if you just think about what the representation would be in these circumstances, on the assumption there has been a renunciation, the representation by Uniserve, the sellers, is I am not abiding by the contract, I am not taking any goods in the future. That's the representation. It's difficult to see how you can from that get a representation that if you seek to hold me to the contract, you are no longer required to comply with your obligations before I must act. One's got to identify what is the representation that would excuse Hitex's performance under the contract. And it would have to be along the lines of, if you can keep the contract open, nevertheless, you do not have to perform your obligations. And one can never get that or it's very difficult to see how one would get that from a renunciatory breach, which is, I am not going to be performing, full stop. But if you do perform, then obviously I'll pay. And the judge mentions if one looks at tab 16, at tab 16, page 232. He's been dealing with at 375 that it's not a severable contract.
Sorry, I've got the pages and the paragraphs mixed up, I suspect. Give me them again.
I suspect I have. I apologise. It's page 232 at paragraph 372. And at paragraph 372, he deals with that it's not severable, it's an entire contract. And then at 373, he makes the point that time is of the essence in relation to high-tech's obligations. However, time was not of the essence in relation to Uniserve's obligation. If, as already happened before the 17th, Uniserve failed to collect a delivery on time, that was a breach of contract, but not one that gave rise to a right of termination. It could only give rise to a right of termination if high-tech served a notice, giving Uniserve a reasonable time to meet its obligations to accept the goods and providing that high-tech would treat it as a breach of contract, a failure to perform its obligations within that reasonable time. This is entirely different to the case put forward on behalf of high-tech that Uniserve needed to provide reasonable notice of an intention to collect deliveries that have become due but have not yet been collected. I see that there might be an argument on fairness or estoppel grounds to state that Uniserve, having defaulted in its collection obligation, would need to act reasonably in fixing a time for collection. If this is to be taken to mean a period of hours or days to arrange a convenient time for collection. I do not accept, however, that if high-tech was affirming the contract, high-tech had a right not to meet its obligations under that agreement to have masks available by particular dates, so that if it had not already manufactured the goods, it would be given weeks or months to catch up with the manufacture. So he rejects any idea that there is some sort of long-term representation.
I mean, you don't disagree with that?
I agree with that.
You agree with that?
Yeah. But it's difficult to see how one gets some form of estoppel or representation out of the idea that I'm not going to perform the contract. That means you don't have to if you affirm it. It's just difficult to see how one even gets it off the ground. There's a slightly odd pleading point in my learned friend's skeleton that I think I've got to deal with before I finish this topic, which is if one goes to the Core Bundle tab 11, it's under a heading, no pleaded defence. And it suggested that Uniserve didn't plead that high-tech failed to perform its obligations of delivery, i.e. having the goods available to collection ex-works by reason of high-tech...
Where are we reading from?
Sorry, page 122, paragraph 16. I beg your pardon. It said that Uniserve didn't plead that high-tech failed to perform its obligations of delivery, i.e. having the goods available for collection ex-works by reason of high-tech cessation of manufacture in mid-July 2020. Save for Uniserve's purported termination, there was no pleaded issue between the parties that high-tech continued to perform or that the supply contract had otherwise come to an end, and that wasn't recognised as an issue by the judge, key issues. In its re-amended particulars, high-tech pleaded it had ceased further manufacture of face masks in mid-July in reasonable mitigation of its loss by saving further manufacturing costs in circumstances where it was unable to sell the goods, justifying a departure from the prima facie measure. Uniserve denied there was any good grounds to depart from the prima facie measure, inter alia not admitting the cessation of production, but denying the cessation constituted reasonable litigation. Uniserve further criticised High-Tech for retaining 15 million masks. Uniserve didn't rely on the cessation of manufacture after mid-July, either as a breach entitling it to rescind the contract by 11th at the latest, or as a defence to its own breach of its obligation to accept the goods. Now, it's not quite clear what that is going to in terms of the respondent's notice, except as suggested, I think at page 123, paragraph 23, that had the issue been raised in pleadings, High-Tech itself could have amended to plead, for example, acceptance of Uniserve's repudiatory breach, potentially in similar terms to the judgment, or estoppel. I think what's being suggested is, if we had said that they'd failed to perform, then High-Tech would have run an estoppel argument. I can't see how it goes to the first point, that could have amended to plead acceptance of repudiatory breach when that's not being pursued before your lordships. But there seems to be a suggestion that they would have run an estoppel argument below if they had appreciated that Uniserve was saying, if you keep the contract open, then you must perform it. And the reason why we say that's odd is that all of this was put in, not only was it put in issue, it was all argued, and as you lordships have seen from the judgment, the judge deals with all these points by dealing with the submissions made by High-Tech. So it's difficult to, at this stage, understand what it is that is said was not put in issue in relation to their duty to continue to perform if they affirm the contract. And if we look at the core bundle, page 24,
Is it wrong that Uniserve did not plead that High-Tech failed to perform its obligations of delivery?
no, it's right. Sorry, it is wrong that they didn't do it because they did do it.
377.
In other words, they did plead it, you say.
Yes.
Is it page 377? I'm just trying to figure out where you say you did.
That's going to be my next question.
Yes. Yeah, so, yes, your lordship's right. I was going to actually go though first to, if you go to tab 24, you'll see the re-amended particulars of claim. And if you go to 357, you can see at the bottom of 357, 19b, High-Tech had available sufficient quantities to meet each instalment as it fell due. Uniserve refused to accept any further instalments and to fail to procure that Majlan was at the factory at each subsequent agreed delivery date in order to accept and collect such instalments. And then, as your lordship correctly says, if you then go to the next tab, to 376, the bottom of the page, the first sentence of 19b is denied, which was the allegation that they had sufficient for each instalment, given High-Tech's admission that it was in repudiatory breach of the supply contracts for its failure to meet deliveries, and that at paragraph 24ba, the claimants say High-Tech did not continue to manufacture units in respect of the supply contract after circa mid-July 2020, as continued production wasn't required to meet the instalments. So it's clearly put in issue that they couldn't perform the contract. And the other relevant part of that is at 380, paragraph 13.6. It's not admitted that they had 15 million units available. So the question whether High-Techs continued to perform the supply contract or were able to do so was an issue joined in the pleadings. And if you go to the supplementary bundle, at tab 10, one can see at page 273 where at 117 Uniserve say the fact that by July High-Techs only had around 18.4 million masks as against the revised schedule, which required 22 million, was put to Mr. Carter. And then there's an issue about stock. And then at 117C, the claimants made the submission in Mr. Carter's cross-examination that it is a point of law whether missed deliveries constitute abandonment of various orders. The point is wrong. Such an argument would permit High-Techs to recycle the very same goods over and over again and claim damages and be overcompensated on the false basis that it was manufacturing far more goods than it ever did. So the recycling argument is referenced in closing. And if one goes to 275, at 119, quantum available market and mitigation, High-Tech's claim for 23 million in damages for non-acceptance of the goods is legally perplexing. High-Tech's never terminated the supply contract, alleging repudiatory breach by Uniserve. It's not therefore entitled to loss of bargain damages. This was explained by Uniserve in oral openings. Having kept the supply contract alive, the correct analysis that any loss falls to be assessed by reference to the loss is the same by High-Techs as each delivery of each batch of masks was not accepted by Uniserve. The court knows Uniserve's position. High-Techs did not tender the mask for delivery on the stated dates. Thus, the condition precedent for asserting Uniserve wrongly refused to accept the goods has simply not arisen. If High-Techs had tendered the goods and Uniserve failed to accept and pay for the same, the starting point under Section 50, assuming an available market, is to look at the market price that High-Techs could have attained for the goods for that batch. This is a form of deemed mitigation, that is, the seller is deemed to have gone into the market and sold their goods on the time fixed for acceptance, and difference between that sum and the measure of loss. On this measure, what High-Techs actually did is irrelevant. So the matters that are referenced in the respondent's notice were all being debated in front of the judge, as you've seen from the judgment. And if we go to the next tab, tab 12, 11, go to tab 11, you can see these are the closing submissions by the third and fourth parties. And counsel for the third and fourth parties obviously got quite exercised by this point, because if you go, please, to page 296, you see at the bottom of the page, paragraph 26, the case on loss, more than just a pleading point. On Maritech's Dr. Stead's case, High-Tech's case on loss is academic. They're not liable to Uniserve, even if Uniserve is liable to High-Tech's. But their understanding of the claim for loss is set out below, not least because the court could justifiably be puzzled by the complexity of each of High-Tech's and Uniserve's submissions so far. And then the point is this: where a seller delivers goods pursuant to a sale contract and the buyer refuses to accept them, the seller has a choice, which is 271 and 272. And then paragraph 28, High-Tech's difficulty is that it took neither option. It didn't accept any repudiation so as to bring the supply contract to an end, nor did it continue producing and tendering masks for delivery so as to access Section 50 damages. That's not a mere pleading point. The point is that Hitex's conduct didn't give rise to any claim known to law. It is effectively claiming damages on the basis that it kept the supply contract alive, but then failed to meet its own obligations under it. This is not a case for damages of any kind, regardless of issues of mitigation. Rather, it's a case of mutual breaches. The seller who opts to keep a repudiated delivery of a contract alive can't then claim the price for the goods it never manufactured or tendered for delivery. The incoherence of Hitex's position as a matter of substance and not merely a pleading is apparent from known production records. According to these records, Hitex only ever produced a fraction of the 77 million masks for which it now claims the price. Even it is assumed that all the masks available post 14th June were fit for contractual purpose, with nose clips, which is an unsafe assumption as set above, Hitex's claims in respect of national deliveries on the 12th, 13th, and so on, that its own records show it's not in a position to make. That is because if Hitex had nationally delivered all instalments due up to the 12th, and it claims the price for those deliveries on that basis, it could not have filled the delivery due on the 12th or any later delivery. So, the point is completely in play. It was in play on the pleadings, and it was in play in the submissions, and your lordships have seen it in the judgment. And the final of these is if we could go, please, in the supplementary bundle to tab 19. Paragraph, so this is page 339 of the bundle, and it's the bottom right, page 68 of the transcript, where Mr. Mordaunt says the claimants rely upon a number of Victorian authorities to make this recycling point. And I understand from Mr. Campbell's closing argument that he has a particular beef with the Victorian authorities cited for the proposition, so that a seller is able to recycle goods. I'll leave those to him. You'll note in particular on the question of decision that the seller is faced, that is found in Benjamin. There's no need to go to it. The short point is we have our position on delivery, and unless there is a delivery, no course of action arises for wrongful acceptance of the goods. So the points are all in play. No estoppel argument was raised. It's therefore too late to raise it. That's the reason why there are no findings of fact by the judge on either representation or reliance. But in any event, is wrong, because you can't find a representation out of a renunciatory breach. So, my lords, those are my submissions on grounds 1 and 2 and the respondent's notice. Unless I can help you further on those, I was going to move on to grounds 3 and 4, which you'll be pleased to know are much quicker.
Yes, all right. Thank you.
Ground 3 is a short point, which is, if we look at the core bundle tab 7, the judge held at 266 that by not specifically reserving rights to sue for prior breach, Uniserve was regarded as having waived preceding breaches. The judge erred in law and in principle by doing so, and should have held that clause 26.4 of Schedule 2 of the supply contract preserved Uniserve's rights to terminate for accrued breaches. And 2, the emails giving rise to the revised schedule did not, when properly construed, give rise to a waiver. And 3, an extension of time is a mere indulgence and has no effect on prior rights as established by Nikon Corporation and Gatol. And in relation to number 1, again, that point was argued in front of the judge, but he just didn't deal with it. And it arose in these circumstances. A significant issue at trial was whether the third and fourth parties had concluded a revised schedule on Uniserve's behalf. That was the first point. And the second was whether this had the legal effect of waiving Hitex's accrued breaches of the supply contract. And as I've shown your lordships, it was admitted that they were in breach of the original schedule and were behind by about 21 million masks. And I've shown your lordships the 2 documents that constitute the revised schedule. And the judge concluded that by authorising Maxitrack instead to conclude the revised schedule, that agreement also waived Uniserve's right to terminate for the accrued failure to deliver 21 million masks. And he deals with that at tab 16, page 212. Very short. What he says at paragraph, on page 212, paragraph 266, having regard to the evidence and the discussion above, I consider the parties did agree to substitute the revised schedule for the original delivery schedule in the supply contract. I consider that in agreeing to this and not specifically reserving rights to sue for prior breach, Uniserve must be regarded as having waived as breaches the preceding failures to meet the original contract. That's what he finds. And we say that he's wrong for three reasons. First of all, that the judge failed to take into account or even mention clause 26.4 of Schedule 2 of the supply contract, which your lordships will find in tab 27 of the appeal bundle.
You showed us that.
Yeah, I showed you that. If your lordships have got it, it preserves the rights. So that was the first point, that a failure to either insist upon strict performance it does not waive the breach.
Well, we're not talking really about waiver here, are we? We're talking about affirmation of the contract.
Yes, but yes.
How can you agree a revised schedule, but at the same time retain the right to terminate at any point, like a sword of Damocles?
Well, there is. I only have 3 points. The first point was the clause. The second point was that the revised schedule doesn't refer to what was to happen in the past. And our submission simply is you're not affirming if you have a revised schedule going forward. That is not a waiver if you have a contractual right to terminate under the contract. That's the short point.
So you retain the right to terminate at any point during the ensuing deliveries. You could at any point say, right, we terminate.
Yes, if we were right on this point.
So you could accept a delivery or two,
yes,
and then say, no, we've had enough now, thanks very much.
Yes. So that's why we say it's a short point, that the contract says you can do that under clause 26.4, and there's nothing in the schedule that doesn't say that, and there's a good commercial reason why you would do it, because you might want further instalments, but you want to retain the right that you haven't got 21 million.
26.4 isn't dealing with affirmation, it's dealing with breach.
But it's saying that, well, yes, but all affirmation effectively is waiving a previous breach. And if you have something that says nothing you do will waive that breach, then simply revising the schedule going...
You can affirm a contract, still sue for damages for breach. You're not limited to... Your remedy for breach of contract isn't limited to accepting repudiation.
No.
You can say, I'm going to continue with the contract, but I'm going to sue you for the breach.
Yes, but clause 20, all I'm submitting is the clause, the judge failed to deal with clause 26.4, which preserves rights, including to terminate the contract.
Right. Anyway, that's 2 points. What's your third one?
The third one was, in effect, similar to the second point, which we've got in our skeleton, which is the authority that a change to a schedule going forwards might be an indulgence in respect to future schedules, but doesn't affect what happened in the past. So those are the points on that.
So can I just make sure I have understood what your case is? So you have a schedule. The supplier fails to meet delivery 1, time being of the essence. The buyer does nothing about it until time for delivery 2 comes along, and then says, okay, we must agree a revised schedule.
Going forwards.
But inevitably, including within that the catch-up of the failed delivery, and then the seller does catch up and delivers in accordance with the revised schedule, so the buyer has all the masks in accordance with the revised schedule. and then turns around and says, but I'm now terminating because of the failure to meet the first delivery.
Then it would have no damages.
Well, it might. There
might be
two,
limited damage.
There are two things. One is does the revised schedule preserve the right to terminate, and the other is does it preserve the right to damages if, for example, the buyer suffers damages because he got the goods in June instead of May when he should have done.
Yeah.
In which case, I think Mr. Lewis accepts that the latter right would be preserved, but he says, well, that's not your claim, and not a claim that you made, so it's a concession that he can make quite happily.
Yes.
I mean, if it was always known that you were buying, the buyer was buying to on sale, and in this particular situation, as I understand it, that was presumed, then it's quite possible the buyer would have damages for the original late delivery, which he might be able to claim. But I'm more interested in your assertion is he can, notwithstanding having agreed the revised schedule, which has then been met, he can actually just go back and, at any time and terminate.
Because that's what we say the effect of clause 26.4 is. If you take the view I'm wrong on that, then I fail on the point.
Anyway, that's ground 3. You may have perceived that it's not falling at the moment on terribly fertile ground, but that's what you want to say about it.
Well, that's all I want to say about it. You may perceive that I'm very happy to move on.
Yes.
However, ground 4 is a bit slower, and I do want to take a bit more time on that.
Yes?
There are two issues. We've debated the first one, that if the contract's open and you don't tender, then you have the right to terminate. But the judge doesn't look at the position as at the 11th of July. And I dealt with that, I think, this morning. The second point was the 15%, which I haven't yet dealt with.
Yep.
And the difficulty seems to be that it was always Uniserve's case that it terminated either sometime between the 17th and the 19th of June, or alternatively, that it terminated by the 11th of July. And that point was always an issue, the two. And one sees, if we go to the supplementary bundle, at tab 7, page. So this is, at tab 7 is Uniserve's opening skeleton. And if one goes to 139, paragraph 85, you can see that it refers to the pleadings, that it terminated the supply contract by the 19th of June, or alternatively the 11th of July. And if you want the pleading, that is in the...
Sorry, paragraph 83.
85.
85.
5, I'm so sorry.
No, I'm sorry.
My hearing, not
Right, maybe
speech.
maybe me looking at too many numbers at once. I apologise. Bottom of page 85 is the opening, and that picks up what had been in the pleadings at the appeal bundle, tab 25. At page 378. Paragraph 10.7. Where you can see Uniserve did so terminate the supply contract through its agent Dr. Stead by the 19th of June, alternatively the 11th of July, and then after the amendments, you can see in black on 11th of July, Mr. Stead wrote to Mr. Candour on at least 2 occasions and then quotes the communications, including the one we looked at this morning, earlier. So the issue of the 11th of July as an alternative to the 19th of June was pleaded and put before the judge. And I can take it reasonably quick because I've shown how the judge deals with this topic. And I just want to just show you again to pick it up. We go to tab 16, page 224. He has dealt in leading up to paragraph 327 on the calls between the parties. And then he goes on to the production reports, the evidence from the production reports and delivery notes. And you can see that at 334, the only ones he's dealing with is up to the 14th of June. And just to show you what these documents look like, if one keeps that open and goes in the supplementary bundle to tab 42, at 42 and 43, we've got 2 examples of the production report, and I'll deal with the one at 42 at page 434. And you can see the top right is a date, which is just the printout date. The middle is the date for the actual production report. So this one is 21st of June 2020. You can see in the second column disposable face masks, and in the third column it says box times 50, which means a box containing 50 masks. The fourth column, the 114151, is the number of masks, a number of boxes at the beginning of the day. The next column, the 0, is the number of masks manufactured. The next column is the amount sold. And the final column is the number of boxes at the end of the day. So here it's you can see the figure of 113131, and then you multiply that by 50 to give you the number of masks. And so when you go back to the table at page 225 in the core bundle tab 16, you can see that the numbers in the warehouse are derived effectively from these production reports by taking the number of boxes multiplied by 50. And he then...
Are we at a convenient moment or approaching one?
Yes. Having explained what the production reports are, it's a good time to stop.
Tell us how important they are at 2 o'clock.
Court round is able to